So what I want to talk to you today about, if I may, is try to zoom out a bit from some of what we're doing on a day-to-day basis and what you're doing on a day-to-day basis as advocates. I say we because actually that's one of my jobs. I am an advocate in court. That's what one of my job descriptions, of course, but that's not advocacy as we're talking about it today so much. I want to zoom out and think about advocacy as the support for legal capacity. The reason I want to do that is because I'm going to do a quick show of hands. Who here in this room has heard of the Convention on the Rights of Persons with Disabilities? Yep, that doesn't really surprise me. That's about half of you. It's astonishing that we haven't heard of it. We signed up to it in 2009. It was a convention, a UN convention, which was concluded in 2006. It was ratified by more countries than any other convention in history. It was a unique convention because the people who were most involved in framing it were people with disabilities. And overseen, if you see the Committee on the Rights of Persons with Disabilities, it is astonishing. Watch the footage of their meetings in Geneva. They had the United Kingdom. Our civil servants went to report on our compliance with the convention in August. A group of people with disabilities, some of them profound, interrogating and holding the civil servants in this country to account, is amazing and astonishing. One of the things that they said, and they regularly say, in their reports on compliance of these countries with the convention, we just had our report, end of August, we got about 0 out of 10. Partly because of the age of austerity and the effects, but what I want to concentrate on for today's purposes is the committee's observations and recommendations in relation to how we approach capacity. Because Article 12 of the UN Convention on the Rights of Persons with Disabilities says all people have legal capacity and have the right to legal capacity, which should be recognised on an equal basis, irrespective of disability. Because if that doesn't exist, frankly, everything else is irrelevant. Because legal capacity is the ability to hold rights and duties and to exercise those rights and duties. It's to be recognised as a person in law. Someone whose voice needs to be listened to, actually needs to be listened to as a person. So it's to hold rights and duties, be recognised as a person, and to exercise those rights and duties, to have agency, actually to go out and say, not only do you need to listen to me because I hold rights, but you need to act on what I say. So if you think about it, your job is so centrally focused on this, the exercise of legal capacity. And in the context of people with disabilities, that is about the most important thing we can think of. So let's just zero in and see what the Committee on the Rights of Persons with Disabilities have said about us, about the UK. Apologies, the text's a bit small. I think it's in the packs, but I'll read it out. I have utterly failed on David Schneider's social media picture front. I'm sorry. And big text. I'm a lawyer. I like text. So, the committee is concerned about the legislation restricting the legal capacity of persons with disabilities on the basis of actual or perceived impairment. The committee is concerned about the prevalence of substituted decision-making in legislation and practice, and the lack of full recognition of the rights to individualised supported decision-making that fully respects the autonomy, will and preferences of persons with disabilities. So the committee recommends that the state, in close consultation with organisations of people with disabilities, nothing about us without us, abolish all forms of substituted decision-making concerning all spheres and areas of life by reviewing and adopting new legislation in line with the Convention to initiate new policies in mental capacity and mental health laws. It further urges the States Party to step up efforts to foster research data and good practices of and speed the development of supported decision-making regimes. If that's taken seriously, that means the abolition of the Mental Capacity Act and the abolition of the Mental Health Act. You may or may not be surprised to know it is very unlikely that the government is going to do either, or in particular, latter, abolishing the Mental Health Act. If you've seen, for instance, the terms of reference for the independent review of the Mental Health Act, not a mention of the CRBT at all. There are some huge issues about whether this demand actually goes further than what is contained in the Convention, and also what the ethical, principled response to it is. But at an absolute minimum, it is the most enormous wake-up call for people who think, for instance, that the Mental Capacity Act is still world-leading 10 years after it came in, because it came into force 10 years ago on the 1st of October. And what I really want to just dwell on for today's purposes is the bits in red. Good practice in supported decision-making. Because what I actually want to say that you're doing as advocates from a whole range of different backgrounds, a whole range of statutory forms of advocacy, IMCAs, CARE Act, IMHAs, informal advocates, whole range of different types of advocates. What we're actually doing, what you're actually doing already is, to a very large extent, the practice of supported decision-making. And one of the reasons why I want you to think about this is as we formulate a response as a society to this challenge which has been laid down, we need to be thinking about what are we actually doing on the ground that really constitutes supported decision-making? How can we build that? How can we actually operationalise? I'm sorry, it's a horrible word, but I'm a part-time academic and that's a word I use wearing my academic hat. How can we operationalise legal capacity? So, first, looking in the context of mental capacity, because everyone always thinks legal capacity equals mental capacity. No, it doesn't. Legal capacity goes much, much further than whether or not someone has the functional ability there and then to make decisions. But just thinking to start with about mental capacity in the mental capacity zone. Well, obviously good practice is challenging mental capacity assessments, actually giving effect to the most important principle in the Mental Capacity Act. What's the most important principle in the Mental Capacity Act? Is a rhetorical question, but if anyone really wants to answer, they can. The most important principle by miles in the Mental Capacity Act is a person cannot be said to lack the capacity to make a decision unless all practicable steps have been taken to support them to make that decision without success. It's called the Mental Capacity Act for a reason. The Law Commission, back in the day, wanted to call it the Mental Incapacity Act, and everyone legitimately said, that is a terrible message, because that is giving the idea we are trying to find people lacking capacity and then go and do things to them. So can we please call it the Mental Capacity Act? And those of you who know me know I'm a mad advocate of the Mental Capacity Act, even under this challenge, but the bit I like least, almost, apart from Doles, putting Doles to one side, which is a disaster zone. The bit I like least about the Mental Capacity Act is we've got the principle, all practicable steps, we've got nothing in the Act to actually bear it out and say, if you don't do this, this has a comeback and has a consequence. And enthusiasts who've read the Law Commission report, one of the things we recommend is that for serious decisions, if you can't actually show that you've supported someone, people will not have a legal defence to acts that they carry out in consequence. Not nice, not cuddly, but trying to find a way to actually give reason to it. So for an IMCA, merely taking, oh, well, this person said to lack capacity, I will move into the best interest zone. No, sorry, that's too late. That's missing the boat. It's why are you saying is this person lacking capacity? And asking the simplest question, I really like the fact Kate was saying, ask simple questions. The simplest question I can ask any health or social care professional when I'm cross-examining them in court, I'm very nice, but I'd ask nice questions. The simplest question would be, I'm really sorry, what did you do to help this person make their own decision? It's a very simple question, very, very difficult to answer unless the relevant people involved have in fact taken the right steps. And then I can make in my closing submissions, or you as an advocate can equally make the point, they haven't taken practicable steps. The law says you cannot be taken to lack capacity unless all practicable steps have been taken. Therefore, every single piece of your decision-making thereafter is flawed. So, challenging capacity assessment is the obvious part of supported decision-making. But it really doesn't stop there. Some people get terribly hung up on supported decision-making, thinking it's solely about supporting people to take their own decisions. No, it's not. If you think about it, it's the context of the ability to hold rights and duties and to exercise rights. If you are ensuring that the person's wishes, feelings, beliefs and values are respected in a best interest decision-making process, you are ensuring, as best you can within our current legal framework, that this person's agency is respected. You are enabling that decision to be carried into effect, or that person's wishes and feelings to be carried into effect. Obviously, the MCA doesn't say, if you can identify what the person would want to do, you need always to follow that as a best interest decision. But the case law is changing and changing and changing. The Law Commission proposals ever stronger. The person's identifiable wishes and feelings are the place we start, and they're the place we construct the decision around. So that's crucial outside court, in all those areas where a best interest decision is being made. I much prefer the idea of constructing a best interest decision to making a best interest decision, because constructing means we get the process of what we are doing. We are pulling together the right bits of information, asking the right people, involving an advocate where we need to create the decision which, as Lady Hale said in Aintree, is right for that person as an individual human being. Inside court, advocates have an incredibly important role, both as advocates. I think Jackie Cowley, I don't think she's here today, unfortunately, but Jackie played the most important role in the Briggs case, which some of you will know. This was the man, the traffic policeman, who was very badly injured, head injured, in a car crash. And the question was, should his life support be continued, his artificial nutrition and hydration be continued? And Jackie played the most important role as IMCA in bringing to Mr. Justice Charles evidence of what Mr. Briggs would have done if Mr. Justice Charles had been able to ask him the one question he couldn't, which was, do you want this treatment to continue? And she did such a good job that, combined with the evidence of the family, Mr. Justice Charles was able to say, not only do I know on the balance of probabilities more likely than not what Paul Briggs would have done, I can say on the criminal standard, I know beyond reasonable doubt that he would not have wanted this treatment to continue. So, incredibly important role. Advocates can also play an incredibly important role as a litigation friend for the person in court of protection proceedings. I'm not going to talk further about that because Peter's workshop, for those of you who are going, he will be drilling down into that into detail. So this is all part of supporting people to exercise legal capacity. Still in the mental capacity zone, all these other tools to enable people to have their status as a rights bearer respected. Powers of attorney in situations where someone currently has capacity to make decisions but is concerned that they're either going to lose them permanently or fluctuating. That is supporting someone to exercise their legal rights. Advanced decisions to refuse treatment, incredibly important. And also, can I just make a tiny plug, please? It's a project which I'm involved in and I think is enormously important. We all know do not resuscitate notices are appalling and wrong and are dreadful in a number of different ways. One of the ways that they are most dreadful is that they focus people's attention on one very specific thing which may or may not work. It's one of the three big myths of the world. One, there's a thing called next of kin. No, there isn't. Two, there's a thing called common law marriage. No, there isn't. And three, CPR works. No, it doesn't most of the time. But people get so fixated about it that they forget what the interesting and important thing is. What is this person's priorities? What do they most want? Do they most want to be kept alive at all costs, or do they want to be made comfortable? And Respect, up there, and I've given you the website, is being piloted at the moment to replace Do Not Resuscitate notices. And the best thing about the form is it starts with a graphic. They'd obviously read David's guide. It starts with a graphic, a scale, where it allows you to put what's most important to this person. Either with a person expressing their views themselves because they've got capacity to participate, or through the equivalent process of consultation that would go on in the making of best interest decisions. And that guiding set of principles then allows people in a medical emergency to know what the right thing to do is. So these are all, I'm just giving you these in the mental capacity zone, are all things where we are supporting people to exercise legal capacity. And I want you to think that is what I am doing. Because we need to formulate a response to the committee's challenge, and it is a very real challenge, which starts, well, firstly, from the people we are supporting, second, the people who are actually doing the supporting on the ground, and very lastly, with people like me drafting laws. We should be at the end of the process and then arguing about them. And then lastly, can I just please also make a massive pitch for this? Legal capacity goes so much wider than mental capacity. Supporting someone is as an advocate, for instance, in a Care Act assessment procedure, is supporting that person to exercise their rights to ensure that they get the appropriate assessment of their needs and they get the appropriate personalised care plan insofar as it can be personalised in the current environment, gets the equivalent rights there that they would do if they had unimpaired capacity, unimpaired mental capacity, or didn't have some other difficulty which was making it impossible for them to participate. Those of you who are coming to the workshop that Jess Flanagan and I are doing after this will be looking in particular at the N case in the Supreme Court, where Lady Hale made so clear that people applying the Care Act and its equivalent in Wales and the NHS Act are applying statutory provisions which have their own statutory codes. They are not, for instance, in the context of someone with impaired mental capacity, making best interest decisions. And to support people to exercise their legal capacity and to ensure that options are kept open so that we're not then making terrible, confined, constrained choices on a best interest basis. That's where the advocacy support needs to start, upstream, making sure that the care planning is being done right, applying the right principles, before we then get to the very constrained choice. The other point, and it ties in with something that Kate said, safeguarding. Advocacy support in safeguarding is absolutely crucial. Because if someone is under coercion or duress, their ability actually to make autonomous decisions, their ability to make their own decisions, is so substantially impaired as to essentially be meaningless. And the other thing I would point out here, I forgot to put it up on this slide, apologies. The Convention on the Rights of Persons with Disabilities says one of the obligations on the state of the UK, is to secure the rights of persons with disabilities against exploitation, violence and abuse. So baked into the Convention is a responsibility to ensure that people with disabilities are put in a position where they are protected. And advocacy support, again, is crucial in that. So finally, I would just say there are, of course, lots of practical barriers to the exercise of legal capacity. Even if someone notionally has full mental capacity to make decisions and they are being treated as the capacitous individual, so much of legal capacity really has nothing to do with the law, or it's got to do with navigating the law. It's got to do with navigating ridiculously complicated legal provisions which don't necessarily overlap properly, which is why informal and self-advocacy can be so incredibly important in ensuring people feel empowered, if only to do the things that Kate said in terms of asking the very simple question, why are you doing this to me? And then take it a step further. So I really wanted to zoom out from the minutiae of the stuff which is going to be done in the various workshops about different forms of advocacy and different things and different statutory procedures to try and get us to think at all times, are we supporting this person to be recognised as a person who bears legal rights, legal responsibilities or duties, and should be treated as a person, as a subject, not an object. And we can do that in a huge number of creative ways which flow well beyond the various bits of statutes and the various bits of codes that we should be applying. We need to start thinking in a more holistic fashion there. So I will just conclude, not on end, but I do just need to plug this. Sorry, this is my GIF, my one graphic. If you don't already get our mental capacity law report or newsletter, the most recent one came out just earlier on Monday, in fact. You can get it up there. And all the cases concerned with mental capacity we summarise for free on a database up there. Because one of the things we are enormously concerned about, we are a very nerdy team of court protection lawyers in my chambers. We are enormously concerned about legal literacy amongst people, both professionals, health and social care professionals, advocates, other third sector organisations. If people don't feel comfortable with applying the law, understanding the law and how the courts are looking at the law, we are utterly lost. So we try to write it for non-lawyers. We are lawyers. We do our best. Apologise, sometimes it does sneak into legalese. So that's what we do. If you haven't seen the Sky Mental Capacity Act directory, it's good. My website, the Mental Capacity Law and Policy, or MCLAP, MCLAP, which also stands for Mexican Capital Legal Assistance Program. I don't think I'm helping anyone on death row in Mexico, that I'm aware of. But that has lots of rants from me and resources from me. And if anyone is involved in either mental health work or mental capacity work, please, 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 the mental health law website is brilliant, mentalhealthlaw.co.uk, a free website run by Jonathan Wilson, mostly in the middle of the night because he's got small children. And it's got a fantastic discussion list. You need to ask to join, but if you're an advocate, you can definitely join. And people are very, very good at posing difficult questions and having questions answered in a responsible fashion. And then our book, the Court Protection Handbook, if you need to know, it's got a website alongside it. So that's me done. I think I've brought us more or less back on track, time-wise. So thank you.